So we brought into the studio here today AJ Gupta, our real estate attorney for the program, to help us understand some of the things that happen with the real estate transaction. AJ, good to have you on the show.
Thanks for having me, Craig.
Yeah, so I mean, there's so many things that we can talk about, but I really wanted to focus in on today was the contract of closing. I just recently purchased a home.
Congratulations.
Between the home and the mortgage, the paperwork was about as tall as I am at 6'4". You know, and like anything, I mean, you sign, you don't really look, you sign, you just kind of moving forward. It's dangerous, right? So help us understand the closing process and some of the things we need to know on the legal front.
So in terms of closing, in terms of the purchase process, the two major issues that we see are where either a buyer or seller chooses not to perform for whatever reason.
Right.
And then the second major issue that we see is disclosure. So if you thought it was one thing and then you found out that the foundation was cracked or that there's an unpermitted area or leaky something or something that an ordinary inspection wouldn't reveal. So those are the two major issues that we see.
So in one case, just so I want to make this really clear for our audience, the one case, A, you're bailing on the deal. Maybe your financing fell through, maybe you don't like the home, whatever it may be.
Right.
The other case, you went through with the deal and issues came up. So let's start with the first one. So I want out of the deal. Help us understand the plan there.
All of this goes back to the offer that the buyer put in when they purchased the house. There's something called the California Association of Realtors Residential Purchase Agreement. It's that initial offer that either you saw or you filled out with your realtor or without. About 98% of residential transactions are going to take place on this form. If you're not doing it on this form, you better have a good lawyer and you better know what you're doing, because these are kind of the tried and tested forms that judges, escrow companies, title companies, everybody knows what this is. And so that's where it starts. And inside there's a couple of provisions in there. The three major ones that we're going to talk about are the liquidated damages clause, the mediation clause, and the arbitration clause. These are kind of the world that you live in when somebody doesn't perform. Okay. So two types of breaches, one by the buyer. Now historically, when the buyer breaches, there's actually that liquidated damages clause. So if they put down $10,000, then
as in like the earnest deposit?
Right.
Okay.
The earnest deposit is usually forfeited.
Okay.
Now that's subject to a couple of things because there's a contingency period, right? So you buy the house, you have a period of time where you can do some due diligence, make sure your loan clears, all of that stuff. But once you get past that contingency period and you say, okay, I have no more contingencies, before that, you can back out of the deal.
Yeah.
For virtually anything. I mean,
now it's game on.
Now it's game on, and that's what we're talking about. And that's where that liquidated damages clause kicks in. And it says, hey, look, if you bail out after this point, I get your money. Up to 3% of the value of the purchase price. And it's actually a relatively simple situation.
So now there's the earnest deposit. You get that money, but then when you say up to 3% of the purchase price, is that in addition? Okay, so we're talking strictly the earnest deposit. Got it. Okay.
Yeah. Now, if you happen to put down 50%, then you'd probably be maxed out at 3%. Again, assuming you didn't amend that contract.
Right.
So, probably shouldn't put down 50%.
No, you need a new realtor if they're advising you to put that much money down.
Right. I mean, especially before you waive your contingency. Anyway, so that's the buyer situation. Liquidated damages clause is going to govern. Everything is really kind of buttoned up there. There's some issues that take place in terms of escrow, but they're not huge issues. They just if they become issues, then give us a call and we'll work you through that. On the seller side of things, when sellers bail, it's a little bit different. And in fact, it's more of the exception than the rule. The vast majority of people that breach are going to be buyers for various reasons.
Why would a seller bail on the deal?
They made a bad deal usually.
Got it.
Usually they made a bad deal.
Can you bail for that?
No.
Okay.
No, you can't.
Yeah.
No, you
I have
can't.
some friends that do that when we bet on like the Chargers games and stuff like that. So you can't bail on the
Too late. You shook. Yeah. Yeah, you can't do that. And that's a challenge. And like I said, it's the exception rather than the rule. But usually it involves some type of bad deal coupled with family, right? Somebody else's
disagreement internally. Yeah.
Internally, there's something going on. Maybe the house is owned in a trust, and there's multiple co-trustees, and one person decided to move forward and the others didn't. So usually there's kind of some type of dispute in that arena. But in that world, I mean, historically, when sellers bail, historically buyers have just moved on. Buyers said, okay, you know what? It's not worth the fight. There's another house down the road. I'll fall in love with that house and we'll buy it, right? And so these areas rarely go to litigation. We just had one that we worked through after about 12 months of litigation, and it's painful. And you know, the seller really loved the house, or the buyer really loved the house, and that was the issue. And so, but as the housing market tightens, right, as you get tighter in the housing market, then you're going to see more and more of these types of transactions that are going to, because the buyers can't move laterally because they found the house, they spent a lot of time doing it, and there's not as much inventory out there for them to move laterally to. So I think you're going to see more and more of these as they come along. The important thing to know from a buyer side, or even a seller's side, from that perspective, when this dispute arises, and this is the same with the disclosure issue that we're going to talk about, but in that contract, the second paragraph that we all need to be aware of is this mediation provision. And every dispute that arises out of that California Association of Realtors forms has to go to mediation prior to any litigation. There has to be a formal demand for mediation, and you have to sit down with a third-party neutral and try and work things out. It doesn't have to, but you really waive a lot of rights if you don't. Let me put it that way.
Yeah.
So that's going to be the first step in the process, is to say, hey, what about this closing? And come on, please close. And then when they say no, then you say, look, I'm making a formal demand for mediation. Give them a period. And so you go and you try and work it out. And the important thing to know from the buyer's side, and again, like the seller's side, is that you're entitled to the property. In California, and most states actually, as far as I know, you are entitled to what's called specific performance. You can't measure the value of a home in dollars in theory, and if that's the bargain they made, that's the bargain they struck. So that's probably the most important piece of that puzzle.
Well, there's a whole bunch of things that come with commercial real estate, residential real estate. AJ is our go-to guy if you have questions on the legal end of some of these things. When you're buying a house, you're going to have your realtor, or you're selling a house, you're going to have your realtor, you're going to have the mortgage guy involved. That, even though there's contracts, escrow, title, there's not legal advice really happening amongst all these contracts. So you got to be really, really careful. And one of the things I've always appreciated about you, AJ, is, I mean, you and I have developed a friendship. And I mean, I call you every once in a while. I'm like, this happened. And you're like, don't bother with it. Don't mess with attorneys. You're going to spend a lot more money there than you need to. Here's how you would approach that, and it's going to save you a bunch of money. See, a lot of times I think people are scared of speaking to attorneys because there's going to be a lot of money involved. AJ is going to, honestly, he's going to shoot you straight. He's done it with me multiple times, tell you what you need to do. And if there's a bigger case involved, he'll sit down, he'll tell you all the ins and outs and things you need to know. But I would not go and buy a house or sell a house without having some sort of legal team on my side to make sure that you're approaching it the right way. And I've seen these cases happen many times, and it's just really, really important to have someone on your side. AJ, we'll have you on the show soon. We'll dive into some of these other topics as well. Good to have you on here today.